Okay, everybody, it's gone 12:30 now, and people can join as and when if they're joining late. Can I just say a big thank you for actually attending the Parklane Plowden expert evidence case update in relation to clinical negligence cases. I'm hoping to go through it with you today, and as you can see, there are slides which I'm providing, which hopefully will be of some assistance in terms of going through matters today. Can I also say at the very start that this is actually being recorded for marketing purposes and to be put on the Chamber's website, so everybody is actually aware of that. Just as a starting point, as I say, this is going to be a update on expert evidence in relation to clinical negligence cases. Not each of the cases that I'm going to be dealing with are clinical negligence cases, but it's of note that they do have application in relation to clinical negligence cases in terms of the practical aspect moving forward. Insofar as today is concerned, I think we all realise that in relation to clinical negligence, that any case is only as good as the expert, or indeed as the expert is perceived by the court. I want to go through a number of cases today. I've chosen 7. And as the lecture says, they go from the last quarter of 2021 through not only to the first quarter of 2022, but also through to about halfway through this year, in that one of the cases was only actually handed down in terms of its judgment last week. In terms of the cases that we're going to go through today, I'm not actually going to go through and set out in detail the duties that are to be provided by an expert under CPR 35, or indeed in relation to the Icarian reefer and the judgment that was handed down in relation to that case, which is quintessential in terms of the expert duties owed. I think it's worth remembering, though, that a number of duties are indeed owed by experts, and primarily the first of those is the duty to the court. It's also to be factored into account as well that an expert should produce an independent product of his or her knowledge, and lastly, that they shouldn't act as an advocate of their own case. In relation to matters, what I'd like to say is that as far as today is concerned, I'll be going through each of these cases, and hopefully I'll be bringing some insight into them. Insofar as my experience is concerned, one of the things that I also do is that I actually lecture to expert witnesses who are hoping to do clinical negligence, or indeed update their clinical negligence expertise as medical experts. So I'm hoping that in relation to this, I can bring some insight, not only in relation to the legal aspects, but also in relation to what medics are thinking also. Anyway, without further ado, let's go forward in relation to the cases that I want to consider today. The first case is the case of Robinson and Liverpool University Hospital Foundation Trust and Dr. Chris Mercier. This was a case that was decided on the 9th of September 2021 in Liverpool County Court. I take on board it's only a first instance decision, but I think its application is extremely important in relation to those undertaking clinical negligence work. This involved a general dental practitioner who was giving evidence as an expert witness. It's important in the context of those of us who undertake this type of work, because it actually brings into account whether or not the expert in this case should have been undertaking the case that he was doing as an expert in relation to the issues that were in dispute. As I say, the position in this context is that Dr. Chris Mercier was a general dental practitioner. He was instructed by his instructing solicitors in the substantive action, and the action actually involved surgery that had been undertaken by the Trust oral maxillofacial surgeon in relation to tooth surgery within a hospital setting, and also under general anaesthetic at the Trust Hospital. The case was actually brought entirely on the basis of the expert evidence that had been provided by Dr. Mercier. He was the one who ultimately said, so far as the defendant was concerned, that he was actually negligent in relation to the surgery and the treatment that he provided. The matter went all the way to trial, and at the trial of the action, Dr. Mercier actually conceded that firstly, he'd not worked in a hospital setting other than to observe in the past, and that he'd no experience of surgical removal of teeth since 2000, when he'd actually been in the armed forces. It was actually said at the trial as well by Dr. Mercier quite openly, that he acknowledged that the defendant's expert oral maxillofacial surgeon was better suited to advise in respect of this case in relation to the standards required of an oral maxillofacial surgeon in this setting. So one can see almost immediately it was admitted when the matter got to trial by Dr. Mercier that probably he wasn't the expert that should have been actually instructed in relation to this case. Unfortunately, matters did go ahead, and following the oral evidence, the claimant actually had to discontinue her claim as against the defendant trust. The defendant trust didn't let matters lie. They sought a third-party cost order as against Dr. Mercier himself in the sum of £50,000. That amount actually representing the costs which were actually incurred by the trust since the beginning of the proceedings, and which said by the trust would have been avoided but for Dr. Mercier's conduct. The matter was actually brought to a head immediately after the hearing of the substantive action. Unfortunately, Dr. Mercier himself didn't know that there was a potential for the third-party cost order to be brought against him, because albeit that he should have been listening to proceedings, he blanked his screen and he'd gone to pick up his children from school. The position was in relation to that, as far as matters were concerned, unfortunately, the position was that the third-party cost action was indeed brought as against Dr. Mercier. The position was that it was then heard by Mrs. Recorder Hudson, who'd been the trial judge, and she was actually uniquely placed to actually consider matters moving forward. It was actually submitted by the trust that Dr. Mercier shouldn't have given evidence in the case at all, and that he had an ongoing and continuing duty to the court to ensure that he was the appropriate expert to assist the court, and which he patently had failed to do so until such time as he gave his evidence at trial. The judge herself reminded herself at the outset that the provisions of CPR Part 35(1) and 2 came into account, and that it was the duty of the experts to help the court on matters within their own expertise, and that duty itself overrode any obligation to the person from whom the experts had received instructions or by whom they were actually paid. Insofar as the law was concerned for the third-party cost action, the next two slides do set out what the position is. I won't go through them because they're not really within the remit of what we're discussing today, but it's worth actually considering yourself, if you do have this type of application, to actually contend with what the position is. Ultimately, though, the factors to take into account are simply that it was very exceptional that a cost order would be brought against an expert witness in relation to cases of this type. And it was generally only going to be in regard to matters where there'd been a flagrant and reckless disregard of the duties owed to the court by the expert. So the matter was considered by Mrs. Recorder Hudson, and she set out a very lengthy judgment where she said quite openly that she felt that Dr. Mercier's evidence fell short of that which was expected of an expert witness. She took actually all the matters into account and said that it must and should have been obvious to Dr. Mercier at the outset and at various stages throughout the proceedings that he was not in itself the appropriate expert to opine on the management of treatment that was to be afforded to the claimant in this case. She went on to say that in doing so, he'd shown a flagrant and reckless disregard for his duties to the court, and that this had commenced at the outset, and that he prepared a medical report in a matter in which he simply had no expertise. She went on to say that she seamlessly considered that Dr. Mercier had been the reason why the claim itself had been brought, and that unfortunately this claim was actually brought as against a public body, which had been put through considerable expense in financing a costly litigation that shouldn't have been brought. She also went on to say, in terms of her own considerations, that she observed that a hard-working oral and maxillofacial surgeon had been maligned in public and undoubtedly had been caused significant distress by the actions of Dr. Mercier in bringing the case as against him. It was consented by the legal representatives on behalf of Dr. Mercier at the actual hearing in terms of the costs order, that in fact nobody had actually brought up and into account at any time before whether or not he was the correct expert to be involved in the case. Insofar as that was concerned, Recorder Hudson said that she gave very little thread to this argument, saying that with respect, she couldn't see why it should be the duty of another party to police Dr. Mercier's duty to the court. In respect of any delegation that was to have been had, of course, it would have been said that it would have been the instructing solicitor who instructed Dr. Mercier or the other party in terms of the litigation who should brought matters to a head at an earlier stage. Quite simply, the court said no, that wasn't the case. The duty was firmly upon the shoulders of Dr. Mercier as the expert, and he was the one who should have taken into account whether or not he was the appropriate expert in the case. And in relation to that, the Court of Hudson set out the position in relation to CPR 35, and that experts should make it clear under CPR 35 practice direction when a question or issue falls outside of their expertise. Quite simply, the duty under CPR 35 remains with the expert, and it cannot be delegated to another party. So looking at the case of Robinson, it does bring into account a very salutary warning to all experts. And I've set out here a number of matters which I think are worth consideration. Firstly, they should only ensure that they accept instructions which are within their own expertise. That's almost seen as a given, that they are to help and assist the court on matters that are within their own expertise. Thirdly, that they are to remember and keep their duty to the court in continuum throughout the entirety of the case that's being brought. Therefore, if things change during the conduct of a case, they should bring it to the court's attention at that point in time. And lastly, they should accept that their duty is to the court, and it's their duty and theirs alone, and it's not for another party to arbitrate on the basis of that duty. Now, I've said in relation to this that it's very much the case that the duty is upon the expert, but I think it's worth taking into account that this is the type of matter that could actually raise itself again, and that an expert may try to say that there's also some duty upon the instructing solicitor who instructed him or her in relation to the case. If one looks at this particular case itself, it was almost quite clear that in fact it ought to have been within the remit of a maxillofacial surgeon, but a general dental practitioner was indeed instructed. So it could be said that there should be some duty upon the instructing solicitor themselves. That waits to be seen as to whether or not that is brought forward again in relation to this case. The Court of Hudson said no, but of course it's only a first instance decision in relation to that. So as far as that's concerned, I think it's particularly important that we actually take into account the duty that was set out in the Robinson decision. The second case that I want to have regard to is not a clinical negligence case at all. It's the case of Reynolds and Stanbury. It's a Chancery decision case, but I think it's worth just taking into account for complete cognizance in relation to the duties owed by experts. This was a case that was before construction court, and Judge Barber, in considering the expert witness evidence that had been relied upon by the liquidator, went on to say that insofar as the expert was concerned, that he felt that he had to be reminded what his duties were to the court. And he said this, that in giving evidence under oath, the court process is not a game. It's an extreme example, but one which is to be recognised. In relation to this, I think it's worth taking into account that if one looks at it within the clinical negligence setting, the position is that there are a number of experts who undertake this duty because, as is said by the Royal College of Surgeons in their website, it's a fascinating aspect of work to be undertaken. Now, in relation to that, I think a number of experts look at it, they probably don't know exactly what their duties are under CPR 35, but they want to be involved in something which is outside the normal day-to-day work that they undertake. I think it's also worth taking into account something that was said by Mr. Justice Spencer, who of course is a very experienced clinical negligence judge. And this is in relation to what he said in 2019 before the Expert Witness Institute annual conference. In that conference, he said this: as a judge, it's not enough for me to have an expert who knows everything about neurosurgery. It's useless if he hasn't done his job as an expert. So we can see in relation to these type of cases that what the court is alluding to is that the necessary expertise is required from the experts in relation to the way that they present their evidence. As I say, it's an extreme example, but one that's worth taking into account. The next case that I want to turn to is one that's probably been heard by a number of you, and it's the case of Thorley and Sandwell and West Birmingham Hospitals NHS Trust. A 2021 case that was actually heard by Sewell J. And it's a very interesting case in that it takes into account the interaction between trust guidelines and a breach of duty. What happened in this case, because it's worth taking into account the facts, is that the claimant had suffered from atrial fibrillation. He was prescribed warfarin to reduce the risk of blood clots forming and the risk of stroke. In March 2005, so we're going back quite a number of years, the claimant attended the defendant trust hospital complaining of chest pain. It was determined that a coronary angiogram should be performed as a day procedure. It's worth taking into account at this point the fact of the procedure that was undertaken, namely a coronary angiogram, because it becomes all important. It was actually booked for the 27th of April 2005. Before that, the claimant was advised by the defendant's clinician to stop taking the warfarin for 4 days before the procedure itself. The claimant underwent the arranged angiogram, and he was then subsequently told not to recommence his warfarin until the 29th of April, some 4 days later. The good soul, listening to the advice that had been tendered to him by his treating clinicians, he complied with that advice. Unfortunately for the poor claimant, the very next day, the 30th of April, he suffered an ischemic stroke, and that unfortunately rendered him severely physically and cognitively disabled. The matter came before the court, and the parties relied on cardiology evidence in relation to the breach of duty. Insofar as the defendant was concerned, the expert evidence that was provided by the defendant in this case was by Derek Tufnell, an expert that many of you will have come across in relation to cardiology evidence. The claimant's case was this. It contended that the defendant trust was negligent in firstly advising the claimant to stop warfarin for 4 days before the procedure instead of 3 days, and secondly, for failing to advise the claimant to restart warfarin on the evening that the procedure was undertaken, being the 27th of April 2005, rather than 2 days later, as he was advised. Now, in presenting its case, the claimant actually placed not any great store, but the entirety of its case on a document that had actually been produced by the trust itself. That trust guidance was entitled Anticoagulation and Surgery. And what it did was it actually set out guidance on behalf of the trust in relation to matters relation to angiograms. And it was first published on the 1st of April 2004. And so far as the actual guidance itself was concerned, it specifically provided that warfarin be stopped 3 days before and restarted as soon as the patient was able to take oral fluids. The defendant, looking at it, put forward a very different case, very much based upon the evidence that had been presented by Mr. Tufnell. The defendant said this, that the length of time that the warfarin was stopped before the procedure was in itself reasonable. And it said so because the guidance did not trump a Bohlen-Bolitho defense based on a body of competent practitioners. So it basically relied upon the Bohlen-Bolitho defense and said, albeit the guidance said something different, it was the Bohlen-Bolitho defense that still applied. And it also went on to say that it disputed that the defendant trust guidance document applied in any event, as a coronary angiogram was not in itself surgery. The defendant trust also admitted that the warfarin should have been recommenced the day after the procedure, being the 28th of April 2005, rather than the next subsequent day. But it went on to say that it wasn't causative of the stroke, which would have occurred in any event. Now, Mr. Justice Sewell had regard to all of these matters, and having listened to the application and what was said on behalf of the claimant and the defendant, he said very clearly that the document didn't apply to the procedure. He said that there was no case to answer on the issue, and a précis of his reasons as set out were these. He said, first of all, that the coronary angiography was not surgery within the meaning of the guidance itself. Secondly, there was no evidence to establish that the defendant trust treated the coronary angiography as akin to surgery, which was what it could have been said to have been at its highest. And thirdly, the content of the guidance, when duly analysed, illustrated that it didn't accommodate coronary angiography. And lastly, that there was actually ample cited material which had been produced before the court that supported the omission of warfarin for 4 or 5 days before the angiography had been applied. Sewell J went on to state this, that I therefore reject the case that those advising and treating Mr. Thorley should have applied the identified or any provisions of the 2004 document, nor therefore that there was any breach of duty in failing to do so. Now, he then went also to consider and have regard to the Boland Belitho defence. And what he said in relation to that was this, that what would have been the position had the guidance applied, taking on board the claimant's contention that the defendant trust was under duty to comply with the guidance unless there were good clinical reasons not to do so. Now, as far as this was concerned, it was also the claimant's position that given the guidance, it was immaterial that the responsible body of clinicians would have done otherwise. However, as we can see, the defendant trusted basically countered that argument with the Boland Belitho defence, and that it was established regardless of the existence of the guidance document. He went on to say that if the treating clinician had acted in accordance with the practice accepted as proper by a responsible body of practitioners in the field or speciality, and it had a logical basis, the defence was established immaterial of the guidance or not. Sewell J had little difficulty in accepting that contention that had been put forward on behalf of the defendant trust. Now, in considering the expert evidence that had come before him, and primarily, as I said, that evidence that was presented by the defendant's expert, Mr. Tufnell, he found that there was indeed a body of practitioners who would have advised the claimant to cease warfarin for 4 days before the procedure, and also to have delayed recommencing the warfarin until the day after the procedure itself. He went on to say, therefore, that breach of duty was not established on the issues in dispute. And further, in relation to what was said about the starting of the warfarin the day afterwards, he considered that there was no material contribution to the stroke had it indeed been commenced 1 day post the angiogram. Now, the lessons to be learned from this are these. The case actually identified that while cognizance is to be had of any particular guidance which is provided by an individual trust in relation to a particular procedure, the case cannot simply be built around that guidance of the trust documentation itself. Even where there's been a departure from any matter which is set out in the guidance, it doesn't negate a Boland Belitho defence. So what we have to look at in relation to cases of this type, whilst yes, the expert may be looking at the guidance document which is provided by the trust, the expert also has to take into account the Boland Belitho defence in relation to whether or not that indeed trumps it, because there is a reasonable or responsible body of practitioners who would have undertaken the procedure in the manner that was prescribed and indeed was undertaken. Now, the next case I want to move on to is the case of Palmer and Mantis and another. This is now moving into 2022. This was a case that was determined by anti-Metz Queen's Counsel, sitting as a Deputy High Court judge. It was a case that fundamentally turned upon the allegations of fundamental dishonesty in what was a personal injury claim. The aspect of fundamental dishonesty was in itself actually rejected by the judge. It's important for our purposes, however, because not only was there consideration had in relation to the fundamental dishonesty allegation, but the judge went on to consider very much and to give comprehensive observations in relation to the expert evidence that was before the court itself. Now, at the outset, what the judge said was that he praised the assistance that had been derived from 6 of the medical legal experts who had been and given evidence before him. He described the evidence that had been presented as of extremely high standard, and he went on to say that where appropriate, suitable concessions were made by those experts on behalf of the party calling them in accordance with their duties under CPR 35. However, in relation to 2 of the experts that were called on behalf of the second defendant, he had very different matters to say and played a very different tune in relation to his music. He said in relation to one of those experts, Dr. Torrens, who was a consultant neuropsychologist, that the first report that had been provided by her was littered with judgmental and rather scathing comments. The references to the claimant being self-pitying and histrionic were unnecessary and inappropriate. And he went on to say that he didn't find the way she expressed herself when criticising the claimant went beyond the language which is appropriate for an expert to employ, and also suggests a level of unconscious bias. So one can see that in relation to this, the judge was saying very clearly that he didn't think as an expert under their duties under CPR 35, that they should be actually conducting any litigation in relation to this type of case with that type of language. And of course, what it did go on to show under CPR 35 was almost an implied unconscious bias that had been applied by the experts in the case. So that was what was said in relation to the first expert that was called on behalf of the second defendant. But the judge then turned rather more scathing to the second defendant's other expert, and an expert in pain management. And the judge went on to say this, that in relation to this particular expert, the consultant in pain management, the suggestion in the claimant's opening statement that this Dr. Miller did not believe the claimant from the outset was probably reasonable. Dr. Miller's evidence may have been better if he simply accepted that proposition from the outset. And is all evidence Dr. Miller effectively accepted that position. The judge then went on to consider specifically CPR 35, and in doing so, and if you'll allow me the indulgence, he actually set out this by way of dicta. He went on to say that the duty of medico-legal experts under CPR 35 in the relevant practice direction not in itself be overemphasized. It is essential that they understand their duty is to assist the court by providing their objective, unbiased opinion upon consideration of all material facts, including those which might detract from their opinion and which are not in the best interests of the party who has instructed them. In doing that, the judge had regard to the Liverpool and Victoria Insurance Company Limited insofar judgment, where many of you will remember the position in relation to that particular case is that proceedings were actually brought as against the expert because he'd basically just taken on board at face value what was said by the claimant in relation to ongoing symptoms and hadn't undertaken any objective investigation himself. Now, the judge then went on to say that it's clearly open to an expert to disbelieve a claimant presenting with symptoms in the context of the overall medical records and any other evidence, then or subsequently available to the expert, but there needs to be a strict and close adherence to the Part 35 duty, which shouldn't be departed from either intentionally or recklessly. And he went on to say this, extremely importantly in relation to the consideration of expert evidence, that it was imperative that the court can safely rely upon the expertise of the experts within that field and in accordance with their duties. So the judge very clearly didn't really have a great deal of time for the defendant's pain management expert, and he did actually make a great deal of criticism in relation to it. And he concluded by saying that insofar as the Dr. Miller's evidence was concerned as the pain management, that where there were matters of variance with the other experts, the other side's pain management experts, he provided or preferred the letter expert's opinion in relation to the way that he presented his evidence before the court and the objectivity by which it was presented. What this case actually then shows us, and a very clear understanding, is that there is a need to provide objectivity in the consideration of the evidence as a whole, and that as far as experts are concerned, they shouldn't get into the habit of simply prejudging matters. As far as instructing solicitors are concerned, then, it's really quite important in relation to the reports that if this type of language comes into play, that it's actually taken up with the expert concerned and that the matter could be ameliorated or something done to actually provide for language which is better suited to an expert giving evidence objectively before the court. So it's important as an instructing solicitor to have regard to these aspects. The next case is Dalchow and St. George's University NHS Foundation Trust. This is a quite interesting case because it actually is a decision of His Honour Judge Southey QC, sitting as Deputy High Court Judge, in relation to considerations to be had by way of Bolam and Bolitho, and what's to actually be considered by a judge in relation to those particular aspects of the founding of liability. What he did was he had set out a very detailed précis of the law concerning breach of duty and the approach that was to be taken to it insofar as expert evidence was concerned, and from a judicial perspective, how it was to be viewed and how it was to be considered in reaching a decision in relation to the aspects of breach of duty. What he said is that having had regard to Bolam and Bolitho, he found it very helpful to go back and consider the dicta of Mr. Justice Green in the case of EWHC and North Cumbria University Hospitals NHS Trust 2014. A number of you may be aware of this particular case. It's one that's often alluded to in terms of skeleton arguments or the like in relation to Bowl and Belitho defences in any matter which goes before the court for consideration. Now, in relation to this particular case, what was said by the judge at page 89 of his judgment was this. He said, in considering the expert evidence, what was presented, that in making an assessment of whether to accept an expert's opinion, the court should take into account a variety of factors, including but not limited to the following: whether the evidence is tendered in good faith, whether the expert is responsible, competent, and/or respectable, and whether the opinion is reasonable and logical. The latter part, of course, applying very specifically to the Belitho defence. What the judge then went on to say was this, that in reaching the conclusion, a trial judge had to take into account and be cautious to ensure that they'd not merely decided which expert evidence they preferred, but to take into account matters to determine whether the medical opinions relied upon are reasonable and logical. So one can actually, as part of the judicial process, take into account what is said by the experts and the way that they present it. But the judge was going on very much to say in relation to this Dalchow case, that what ought to very much be taken into account by the judge in regard to deciding matters is whether the medical opinions relied upon were indeed reasonable and logical in order to make a decision. In this particular case, he did find that the breach of duty was established on the evidence that had been put before him, and the treating clinician should have realised that there was some uncertainty as to the diagnosis. And he went on to say that given that uncertainty, it was logical and unreasonable not to undertake further diagnostic examination by way of ultrasound. The claim unfortunately failed, however, on causation issues. We can look at it in relation to this particular case by seeing that it does provide very practical guidance in terms of judicial consideration on expert evidence. And it does actually set out that it's simply not an exercise of which expert is preferred, but rather what can actually be described as a rather more analytical determination of the reasonableness and or logic behind an expert's assessment. It very much therefore stresses the need for an expert to not only give an opinion, but to set out the reasons and logic for the approach that they have undertaken. The next case that I move to is the case of Patricia, Andrews and others in Kronospan Limited, 2022. Some of you may have actually seen the article that I have written and is on the Chamber's website in relation to this. Some of you may also be interested to know that I've also provided a further article in relation to this case, which is going to actually appear in the AVMA quarter newsletter for June. So if you want to, please have regard to that. Now, it's an important decision in relation to clinical negligence, albeit that it was a case that was decided in the Queen's Bench division in relation to the question of a business contract. It's important because it goes on to consider experts' meetings and discussions and what regard is to be had in relation to those expert meetings and the privacy which is contained within them. This was a case that came before Senior Master Fontaine, and what happened in relation to it is that there'd been a meeting of the experts, and Master Fontaine actually revoked permission for the claimant's expert who was instructed to be relied upon in relation to the evidence because of a number of serious transgressions by him and his solicitors. Those transgressions related to matters relating to the expert meeting and the draft report that was produced by the experts. Now, it was a case where there'd been a group action by a number of residents alleging that the defendant was liable to be a nuisance. And the matters did actually go on to actually be determined by way of a discussion between the experts. What happened was that the expert who was instructed in the case on behalf of the claimant had been instructed for a great deal of time and had produced a great deal of evidence in relation to the matter that was before him. Now, what occurred was that the experts met and they had a discussion and were looking at producing the expert joint statement. The expert joint statement, however, went through a number of drafts, and the expert who was instructed in the case and the reports that had been exchanged were discussed as between the experts. What happened was that it then came to the attention of the defendant's solicitors after a period of several months, at which point the report had not actually been finalised as between the experts, that the claimant's expert had been in contact with the claimant's solicitors and had been discussing matters. It actually came into light that the expert had been forwarding what was described as being work in progress copies of the expert statement, and they sent over initially a first draft, albeit that it was unsolicited by the solicitors. Now, Master Fontaine said in relation to that, that the only factor that could be taken into account, the only consideration that could be had, was because the expert sought the views of his instructing solicitors. Now, what happened and what transpired when matters were looked into in further detail was that it came to account that the claimant's solicitors had made 68 comments on drafts which had been produced to them. Many of them were simply typographical or by way of query. However, many of the others commented on suggestions on issues of substance. And it was actually admitted before Master Fontaine by the claimant's solicitors that they had themselves accepted 16 comments on substantial issues in relation to the substance of the discussions between the experts. It was also the position that in relation to the comments made, that the expert and the solicitors had been entering into prolonged email and telephone discussions in which the content and progress of the statement had in itself been discussed. Quite clearly and with quite an ado, the claimant's solicitors readily accepted that it was wrong for an expert to solicit input from instructing solicitors during the process of drawing up a joint statement, just as it was wrong for themselves as solicitors to provide any input. And they admitted quite readily that there was indeed a serious transgression of the rules by the claimants in this matter. Now, the defendant, when the matter came before Master Fontaine, sought and said that the only option open to the master was for the claimant's permission to rely on their expert to actually be revoked. It was said that he wasn't truly independent, but it has acted as an advocate for claimants. It was also brought into account that the expert had been involved in the case for 3 years and had done so at a cost of £225,000 in respect to his fees. The claimants contended that such an approach, as suggested, would be potentially disastrous, as it would involve significant delay in instructing another expert and also significant costs being wasted. Senior Master Fontaine observed that insofar as the primary concern was had in relation to this matter of communications passing between them, that the expert's approach was strongly suggesting that he regarded himself as an advocate for claimants and had not seen himself as independent and had not seen that his primary obligation was to the court. Now, Senior Master Fontaine went on to say that there would be difficulties in suing and revoking permission to rely on the expert, but it had to be taken into account that the court had no confidence in Mr. X's ability to act in accordance with his obligations as an expert witness. And she went on to actually remind the parties that insofar as the duties were concerned, the basis upon which the claimants received permission to rely as an expert, namely his duties under CPR 35, the practice direction, had very much been undermined. She also observed that it was important that the integrity of expert discussion process was preserved to the court, and also that the public could have confidence that the court's decisions were made on the basis of objective expert evidence. What actually happened was that Master Fontaine went on to consider that, albeit that the litigation process had gone a long day down the line and it was in an advanced stage, no trial had in itself been set, and therefore what she decided was that the particular expert could not give evidence, but the claimants were allowed to rely on a new expert, obviously at their expense. She went on to say that had matters surfaced at the trial, then in those circumstances, they would not have been allowed a substitution. Now, the case of Andrews is interesting in that it's come to light only this year in relation to the question of expert discussions and the observations that they've had. There was, however, a case back in 2018, which was in the construction court, where His Honour Judge Davis in BW Trading and Integral had actually stated that the expert should not ask solicitors for general comments or suggestions on the content of the draft statement. So it was very much out there before and for consideration by the claimant solicitors in this case that they shouldn't have been doing what they were doing. Now, the matters to take into account as any instructing solicitor in relation to this are quite clear, that until the joint statement has been signed off by the experts, there should be no contact as between the experts and instructing solicitors by way of conversation, email, or otherwise. Probably said that the experts should be put into a protected bubble until they've had their discussions and until they've produced a final copy of the statement itself. The position is very clear. If approached by your instructing expert, be polite, tell them that you can't enter into any conversations on the substantive matters in relation to the draft statement, and simply remind them of their duties under CPR 35. The last decision that I want to have regard to is the case of Plowden Damon. This is a case that was only decided this week, and it's a decision in the High Court of Master David Cook concerning compliance with an expert report. It is in itself a clinical negligence matter, and it arises in relation to surgery that was undertaken in Belgium at a clinic by a particular expert. What happened in this case is that expert evidence had been provided in relation to Belgian law by expert Belgian lawyers. And the matter came before Master David Cook for determination in relation to jurisdiction and whether or not the case could be brought not simply as against the surgeon himself, but also in relation to whether or not the case could be brought under Belgian law as against the clinic itself. Now, in relation to this evidence, which was actually provided by the experts in relation to the Belgian law, the master concluded that he couldn't place any reliance on the report of the defendant's expert regarding Belgian law itself. He said that because he said, having regard to the report, that it was clearly deficient in complying with practically every requirement required of an expert report as set out under the Practice Direction 3532. What he determined was that he felt very clearly that insofar as this particular aspect it was concerned, he was acting as an advocate on behalf of the client's position, and that he'd not provided a balanced opinion covering the range of possible opinions. From what furthermore, it's also to be said, not only did the substance of what was being said by the expert in this case not comply, he didn't also comply with the form of CPR 35. And the court went on to say that it's important that not only the substance, but also the form of CPR 35 is complied with. And it very much said this also, that a report that fails to comply with the provisions of CPR 35 is to be given little or no weight by the court. And again, to emphasize, that applies to not only form, but also substance. Now, again, regard in relation to compliance with CPR 35 can be had in relation to an earlier case. This is a case of His Honour Judge Simon Barker in the case of Battery Tony and Cook against Cattell and Goldsmith. This was a case where, unfortunately, the expert was actually instructed, didn't really have regard to CPR 35 by way of form or substance, and was heavily cross-examined by counsel for the other side, who did what would seem to be a complete hatchet job. And the position was, insofar as that was concerned, the judge in this case said that he considered the expert evidence adduced by the expert in the case was tainted by the failure to consider or indeed apply CPR 35. And the judge went on to say this, that the expert's evidence was not CPR 35 compliant, and it became apparent that he was unfamiliar with CPR 35. And further, that he'd not really addressed his mind to the approach to be taken by a court expert. So we can see there in relation to expert evidence in the last 6 to 9 months, there have been a number of decisions that are all important for those of us that undertake clinical negligence work by regard to expert evidence. As I said at the outset, the position to remind ourselves is that any case is only as good as the expert who is instructed in terms of the case. The 7 cases that I've gone through do give different permutations in relation to expert evidence and do set out a myriad of different duties in relation to CPR 35. So I think hopefully in relation to those cases that I've referred to, one can see that the courts are indeed having a great deal of reference to expert evidence and the duties owed by experts, and that it's paramount not only upon yourselves as instructing solicitors, but also ourselves as counsel to always have regard to the expert evidence that's provided in relation to the reports by the experts, and ultimately to ensure that the duties that the experts themselves have to provide are indeed provided, and that there is also compliance in relation to the duties under CPR 35. So I hope it's been very much of use to you in relation to the updated expert evidence. And I'd like to thank you all for actually attending. And as I say, that you have actually gained something in relation to the updated evidence. If any of you have any questions, please feel free to put them through on the chat now, and we can have regard to it. If, however, it is the case that you don't really want to put something out in the public view, feel free to actually get in touch with me. My email is actually set out there very clearly, and I'd be more than happy to discuss not only these particular cases, but or anything in relation to expert evidence that you feel you might wish to discuss. So before we actually move ahead, has anybody got any questions that they'd like to ask by way of the chat button? No? Okay, then it would seem, oh, sorry, we do now indeed have one question in relation to it. Oh, thank you very much. I think that's only in relation to, thank you in relation to the talk itself, which I'm very grateful. If there are no questions, then as I say, once again, thank you very much in relation to your attendance today, and I hope that's been helpful. And again, if you do wish to actually ask any questions thereafter, I'm very happy to do so. But thank you once again for attending.